Elite universities panic as new lawsuits threatened over cheating on diversity. Some colleges and universities followed the Supreme Court's decision. Some did not. Yale, Princeton, and Duke Universities face scrutiny from Ed Blum's Students for Fair Admissions over concerns that their admissions practices may violate the Supreme Court's ban on race-based admissions. Unlike other institutions that saw significant declines in Black and Hispanic enrollment, Yale and Princeton reported stable numbers, while Duke saw a slight increase. The percentage of Asian American students declined at all three universities, prompting Students for Fair Admissions to question whether their admission processes are truly race neutral. SFFA President Ed Blum threatened to sue if the universities do not provide detailed explanations for their demographic trends. All three universities have implemented new strategies to increase socioeconomic diversity, such as expanding financial aid, which could explain some of the demographic shifts. But it doesn't really explain all of them, because when the other universities saw drop-offs in certain populations because they were admitting people based on merit, not based on skin color, there's really no legitimate explanation as to why these universities didn't have those trends. If the universities were very, very small universities, that would explain it potentially, because you can have random events happen. But over a large sample size, no, obviously something's wrong. And Ed Blum, who won this case in Supreme Court after working on this for years and years and years, is not having any of it. From inside higher ed, Ed Blum puts colleges on notice over diversity. The affirmative action foe threatened to sue three colleges for allegedly defying the Supreme Court's race-conscious admissions ban. Should others prepare for the worst? Yes, do prepare for the worst, because he's coming after you. He knew very well, and we all know very well, there are always going to be people that will not follow the law because they want to push their agenda. They think it's more important than the law, but they're violating people's constitutional rights. Ed Blum is coming looking for you. Selective colleges began unveiling demographic data for the class of 2028, the first admitted after the 2023 affirmative action ban, and the legal threats are already flying. Students for Fair Admissions, whose lawsuits against Harvard and the University of North Carolina led the Supreme Court to strike down race-conscious admissions last June, wrote letters on Tuesday to the general counsels of Yale, Princeton, and Duke Universities, asking for details about their admissions processes, accusing them of noncompliance with the ruling. In the letters, SFFA President Ed Blum said he's deeply concerned that the institutions had violated the affirmative action ban. After some selective colleges reported stark drops in Black and Hispanic enrollment this fall, Yale and Princeton reported that their numbers had remained relatively stable. Duke reported a slight increase, and that doesn't make sense. All three also reported declines in the proportion of Asian Americans in their classes. So how are you guys singling out the Asian Americans yet again, even after the Supreme Court ban? Who knows, but Ed Blum is going to find out. The share fell by 2 percentage points at Princeton and 6 points at Yale and Duke. In the letters, Blum questioned why Yale, Duke, and Princeton's first-year demographics diverged from those of colleges that reported substantial increases in Asian American enrollment and declines in Black enrollment, such as the Massachusetts Institute of Technology and Brown University. He threatened to sue if universities did not provide detailed explanations of their trends. Quote, "You are now on notice," he wrote. "Preserve all potentially relevant documents and communications," which is something you say right before you sue somebody. Spokespeople for the three universities told Inside Higher Ed that their admissions offices acted in accordance with the ruling. Blum declined to comment for the story. It's clear what these universities did was change their criteria so that they had essentially the same results, except it looks like they punished Asians even more by manipulating their admissions processes yet again. Courts are aware of this kind of thing. It's not like they just came up with their own idea of, oh, let's work around the Supreme Court ban, and that will be fine if they technically do this or they technically do that. Courts do look at what is the net result of what you're actually doing. If it violates what the court order was, the spirit of the court order, it's not acceptable. SFFA sued Yale over affirmative action once before in 2021. The parties reached a settlement in September 2023 under which Yale agreed to stricter enforcement of the ban on race-conscious admissions. Blum's letters are a preview of the potential onslaught of litigation to come from groups like SFFA, which have taken it upon themselves to enforce the Supreme Court decision. One murky outcome of the ruling that Blum appears set on clarifying is the so-called essay carve-out. Chief Justice Roberts wrote in the majority opinion that colleges could consider race as one part of an applicant's lived experience as expressed in a personal essay. At the same time, he said they couldn't use essays as a proxy for affirmative action, a warning that Blum quoted in his letters. Art Coleman, founding partner of the higher ed law firm Educational Counsel LLC, said higher ed institutions have been preparing for this eventuality at least since the ruling came down last June. Blum's latest campaign may spark an escalation, he said, but it was foreshadowed by civil rights complaints and lawsuits that other anti-affirmative action law firms filed during the last application cycle. Quote, "These letters are no surprise," he said. "Institutions have been doing the due diligence and hard work of assuring compliance with this ruling for well over a year. Retraining admission staff, re-examining policies, and the like. I don't think this changes the underlying substance of what the colleges are doing on an admissions front." When lawsuits break out over this, and the people suing get their hands on the email correspondence and text messages that demonstrate and prove that they were deliberately trying to work around the Supreme Court affirmative action ban, they're going to be in trouble. Other colleges with stable to slightly improved racial diversity this fall may be next in the SFA's crosshairs. Williams College reported a small decline in white and Asian American students by 2.6 and 1.1 percentage points respectively, and a bump in Black and Hispanic enrollment of less than a percentage point each. Miki Khan, Williams' chief communications officer, confirmed the numbers in an email to Inside Higher Ed. She said the college was in full compliance with the court decision and attributed the results to race-neutral initiatives that have been underway for years, such as broadening recruitment efforts and replacing loans with grants in 2022. Sonia Starr, a law professor at the University of Chicago, said that Blum's letters were likely more of an intimidation tactic than an impending legal threat. Still, she said, there was a good chance that at least one university will be sued over alleged noncompliance in the near future. She's trying to get the colleges and universities to chill out and keep violating the Supreme Court affirmative action ban. To say that, oh, it's just an intimidation threat, but at least one of you are going to get sued, is not legitimate. You'd say, at least one of you will be sued. This is a legitimate threat. If a third of the three get sued, that's actually bad. That means you're likely to get sued. Quote, "Any particular institution has a good chance at avoiding litigation, but it will come," she said. So you have a good chance at avoiding litigation, but you probably will be sued. Or someone like you will be sued, so just keep breaking the law and kind of don't worry about it. Just dodge the lawsuits. Quote, "Organizations like SFFA have good litigators, and they're going to be patient and wait for a good case to emerge, like they did with Harvard." Well, it wasn't just Harvard, it was also UNC. In the letters, Blum wrote that based on SFFA's extensive experience, your racial numbers are not possible without substantially increasing socioeconomic preferences and eliminating legacy preferences, yet you've announced no such changes, and you've reported no substantial increase in the number of students receiving Pell Grants. It's true that none of the three colleges has eliminated legacy preferences. Only a handful of selective colleges have done so since the Supreme Court decision. But there's ample evidence that Princeton, Duke, and Yale have diversified their classes along socioeconomic lines. The number of Pell-eligible freshmen at Duke has doubled in the past 2 years, from 11% of the incoming class in 2022 to 22% this fall. Yale increased from 22% in 2023 to 25% this fall. Princeton made greater socioeconomic diversity an explicit admissions target this past cycle. Last August, shortly after the Supreme Court ruled against affirmative action, the university formed an ad hoc committee on undergraduate admissions to review how it could act vigorously within the law to achieve the racial and other forms of diversity that are essential to Princeton's excellence. In March, committee members released their recommendations, which included admitting a class at which at least 70% of students qualify for need-based financial aid. The university hit that goal this fall, boosting the number of qualifying students to 71.5%, up from 66% in 2023. Duke also expanded its financial aid offerings last year, and promised free tuition for students from North and South Carolina whose families make under $150,000 a year. Duke's Dean of Admissions told Inside Higher Ed earlier this month that the Carolinas initiative, along with a retooled recruitment strategy implemented last fall, helped offset the effects of the affirmative action ban. Coleman said such efforts clearly had an impact on demographic outcomes this fall, and that Blum's contention that they couldn't be responsible is unserious. Quote, "This is fundamentally a continuation of the noise that somewhat arrogantly suggests colleges must not be complying with the law because their data looks so good," he said. That's offensive, and it fails to fully appreciate the array of strategies that institutions can legitimately pursue to advance their constitutionally recognized diversity interests. Yeah, except put up your evidence because you're going to get sued. This guy in particular, he's going too far out on a limb. And if you get into a dispute ever and someone's going to sue you, don't be mouthy about it. Don't try to put the other people down like this guy's doing. It is unusual to see these results. There are other really important, powerful, and resourceful institutions that were not able to maintain the percentages that this guy's institution was able to maintain. That's the point. When you compare the colleges and universities against each other, something doesn't look right with these guys. So that's why they're getting threatened, and that's why they need to give him some information, or he's going to sue them. In comparing Princeton and Duke to colleges like MIT and Brown, the SFFA letters assume that the numbers colleges are reporting are calculated in roughly the same fashion. But colleges have approached demographic data reporting in a variety of ways, making it difficult to draw telling comparisons. Some colleges, like Duke, reported percentages that added up to more than 100 because they include mixed-race students as two different racial data points. Others, such as Princeton, considered mixed race an entirely separate category. And one data point looms large over any conclusions drawn from year-to-year trends in racial makeup. The number of students who declined to report their race nearly doubled across all highly selective colleges that have released data so far, sometimes by a greater margin than the racial changes at the center of the national dissection of demographic trends. So the admissions people must have told them, hey, look, don't report your race because then we can sneak you into the college and we won't get in trouble. It's so obvious what's going on. Although you never know. Maybe it's possible there is nothing funny going on. But if Ed Blum is going to go to the trouble to threaten you with legal letters, he's not looking to waste his time either. He knows there's something wrong. At Princeton, the portion of students who declined to report their race increased from 1.8% of the class of 2027 to 7.7% this fall, according to the data the university sent to Inside Higher Ed. A value change nearly double the decline in Asian American enrollment that Blum's letter highlights. So yeah, of course, they've told students, look, don't report your race. It's going to help us cheat the numbers. And now look what's happened. Kahn, the Williams spokesperson, wrote that while the college was pleased the demographic makeup of the incoming class had remained consistent, 1 year of data was not enough to draw conclusions, either about a university's practices or about the full impact of the affirmative action ban. Quote, just as we constantly assess and tweak our holistic admissions process and take great care to ensure legal compliance, other schools have and will continue to make numerous changes, she wrote. This makes the environment especially dynamic. 1 year isn't a trend. Coleman said groups like SFFA and Edward Blum himself are not likely to be persuaded by that argument. And while he believes there's no reason to panic, he also doesn't anticipate the enforcement push to wane. Quote, nobody is excited about getting sued, but we're in an era where we all know there's going to be intensive oversight of higher ed from the radical right, he said. Unfortunately, it's going to be more business as usual than an aberration for most colleges. What exactly is so radical about having people's constitutional rights respected? About not creating a standard where you can discriminate against people based on their skin color or gender or sexual preference or religious affiliation? It's incredible that the people who are pushing this discrimination are calling other people radical because they want it stopped. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.